Ladies and gentlemen, it's our pleasure for me and my colleagues to see you here in this room, in this beautiful city of St. Petersburg. The weather is not quite perfect, as I hear, but I talked to some of our international colleagues, and they told me that some of them are visiting this city for the first time. And they seem to have positive impressions of admiration for this beautiful city, and we're very glad to hear it. It's particularly important for this round table here. Our intent here is to discuss the protection of rights of foreign investors in non-jurisdictional ways. If we focus on the notion of foreign investors, then we must say that the key factor here is trust. Our times are often described as hard times or difficult times, but for the Russian Federation, I would say that although the situation is far from easy and perfect, but you will see that this country is growing and this wonderful city is flourishing. The investment potential of Russia is considerable, and we are happy that in the present conditions also such investment is taking place. It is happening. I don't want to advertise by naming specific industries or companies. Let me just mention one example. 250 euros worth of investment into a plant that produces 800 tons of construction glass, and it is going to operate for 20 years at least in uninterrupted process before it needs to stop for reconstruction. A beautiful piece of investment. Last year in this forum, we talked about non-jurisdictional forms of protecting the rights of investors, and at that time we talked about lobbying. We suggested a lobbyist profile. And part of that profile was that this lobbyist must be smoking a big fat cigar, and I was impressed when two lobbyists in the room actually produced cigars and demonstrated that they had them. Today we can go beyond that. Today we will have an opportunity to listen to the panelists that you see here before you, and I would also invite the panelists to be so nice as to answer questions from the floor. But let me begin by giving a big round of applause to academician Tolstoy, Yuri Tolstoy, who is present here. It's a very happy occasion to have him here in our midst. Thank you very much, academician Tolstoy. Now, if Mr. Ivanov agrees to take the floor first, I would give the floor to Mr. Anton Ivanov, Chairman of the Supreme Commercial Court of the Russian Federation. Thank you. Typically, I have to speak about jurisdictional forms of investor protection, but here is a unique opportunity for me to do the other thing. Our subject is non-jurisdictional forms of investor protection. a lot of ground needs to be covered in Russia to for us to be able to say that the rights of investors are fully protected. And I wouldn't confine it to just improving Russia's position in the World Bank ranking of countries. We all know that this ranking has an agenda of its own. The countries on the top of that list are, as you know, countries where it's easy to start a business, but it's not easy to earn good money there. So this ranking is shall we say, pro forma mostly. Those countries are highly competitive jurisdictions, and the ease of opening a business does not guarantee high profits there. In fact, it's very difficult to earn a profit in those jurisdictions. And this is the first point I intended to make. This doesn't mean, however, that Russia doesn't need to work to improve its position in this ranking. Still, my talk is about something else. A more important thing for foreign investors, in my view, is to be able to overcome administrative barriers within a jurisdiction. And this is where Russia is a difficult location for them. And this is something that the state can do to improve the situation, the state and its officials. This is where the state can make a difference and demonstrate that it indeed encourages investment. In my view, we can do that by improving the legislative treatment of administrative procedures and keep improving them in the future. It's my constant theme. I keep saying that it's very hard to find very specific rules about the functioning of our administrative bodies in the Russian legislation. I'll explain myself. Please do. Please explain this to us. So, what I mean is this: the regulations of the different administrative bodies are all different, and the procedures that they practice vary from one to another. The regulation of administrative procedures is far from satisfactory. You can see one government body which has one set of rules, including rules for working with investors. A different administrative body can have a very different set of rules. And this is a drawback. And this leads to abuse sometimes, because lack of a clear-cut procedure makes it possible for individual officials to do what they see fit to do. A clearer definition and description of executive procedures and a unified set of such procedures could be a great improvement. But if we think back to the 1970s, we recall that even at that time this was a proposal made. Still, nothing has changed materially since then. And this constantly creates problems. Let me give you one example. Russian legislation lacks a notion of statute of limitations for administrative procedures. For instance, if our administrators need to perform a certain administrative function with regard to investors, they can take any time they like doing it. For instance, if it's an example of a breach of construction rules, administrative officials can inspect a construction site any number of times with any sort of frequency. If they had a certain limitation, time limitation for that, then they would not be able to repeat this operation several times. And then a private contractor would know that if for 5 years no fault was found with their construction, they can feel protected on that ground, unless, of course, they are doing something really wrong and dangerous. A unified set of such procedures would be a real help for foreign investors here. Another point that I want to bring up. In the cities of Moscow and St. Petersburg, the environment for foreign investors is quite competitive, and they find it far from easy to find a good investment target there. However, in the regions of Russia, competition is very low, yet there are other difficulties there that discourages investors. Underdeveloped infrastructures, lack of professionalism of administrative officials that are charged with working with investors. Some regions are more advanced than others, obviously, and they attract more investment than their neighbors do. But there are other regions which are not so advanced. And this means that the state could do a lot by improving administrative procedures with regard to attracting investors to the different regions. A uniform set of rules, not just across the different bodies of administrative authority, but across the regions and regional bodies of the kind, could help a lot. For instance, foreign investors with experience of working with Tatarstan will find that if they want to invest more in Krasnodar, they're going to encounter a whole different set of rules. Many of them unpredictable, and predictability would be a very necessary feature for investors. So what's lacking is a uniformity of rules for working with foreign investors across the different regions and maybe even municipalities, so that regional laws, procedures, and the behavior of officials could be more predictable. One more non-jurisdictional form of protection of interests of foreign investors might be found in this. At present, there is a lack of state-certified rules or maybe guidelines concerning the typical behavior of Russian citizens with regard to foreign investors. I'm talking about employment practices, hiring personnel. Foreign investor who is contemplating operating in Russia may expect a particular kind of behavior from Russian employees, but these expectations are not always gratified. I hear from foreign investors frequent complaints about what they thought to be cheap Russian workforce, which is not quite so cheap after all, and not quite so highly skilled for the money that they require. So what's needed is more and better work from the bodies that are in charge of working with the personnel and social policies, so that investors could have clearer expectations of what is going to happen with the people that they're going to hire in Russia. The mindset of Russians may be unexpected, and this leads to management mistakes, and investors find themselves defrauded or somehow abused. We're talking mostly about top management personnel. So non-jurisdictional forms of foreign investors' rights protection could be improved today by improving administrative procedures, better regulation, and greater uniformity of such rules. And this is where the government has a big role to play. If such procedures are streamlined, then relations between Russian physical persons and legal entities, and on the one hand, and foreign investors on the other, will be more transparent, more predictable, and more conducive to a favorable investment climate, which will eventually lead to Russia's higher position in the international rankings. Thank you, Mr. Ivanov. Mr. Ivanov spoke about rankings, then he spoke about administrative regulations, about the regulations relevant to the regions, and the, shall we say, psychological standards of behavior. I'd like to go back to the theme of rankings. I have this story to share. Once I was talking to a foreign investor, and he shared with me his experience. He was an owner and manager of an industrial plant, and he was it was an impression that he got when he first visited his enterprise in Russia himself. And this was a lumber yard outside of Irkutsk. It was winter time and the temperatures were -45. He was staying in a village house, and after returning from that trip, he had made a choice for investing and for increasing that investment. And he said, what made the difference was me being there himself. If it had been my deputy that I had sent there, he said, he would have definitely said no. That's the kind of person he is. So my story was to illustrate how all these different rankings may not be a clear guide to the real meaning of the situation. When Mr. Ivanov started talking about lacks of legislations, I can say that we have a good working relationship with the judiciary, but of course legislation is never perfect. As to the regulations, there is this point. The regulations are often created by the same bodies that are going to be governed by them. And this is something that probably needs to be revised. I think we will hear all the panelists first and then allow the questions. I turn to Marta now. And she said that she would not like to follow the principle of ladies first, so I'll save her for the last. And I'm now giving the floor to academician Andrei Lisitsyn-Svetlanov, director of the Institute of State and Law of the Russian Academy of Sciences.
The mic is off.
Microphone.
I am happy to attend the St. Petersburg Forum and share some considerations on an interesting issue that is not only about jurisdiction but also touches upon a number of other issues. More often than not, when you're in an audience of non-lawyers, but not lawyers, but entrepreneurs, you can hear that the government state's attraction as an investment is not only based on the rule of law and legal application, but the atmosphere that exists in the state, in the business environment, the officials, with respect to new entrepreneurs coming from remote areas. Now I would like to get closer to legal issues, and one of the points around creating such an environment or spirit is about the barriers and greetings or welcome or unwelcome as the entrepreneur might feel. The administrative barriers may have a negative impact for the promotion of foreign investment in Russia. However, at present, particularly in the Union of Entrepreneurs and Industrialists, there's a bill being drafted on the supervisory role of the state, the government, where on a level of a federal law, it would be regulated to avoid this negative attitudes that entrepreneurs might face in the various regions of Russia. But this work is at its very inception now. As regards legal, I mean jurisdictional and non-jurisdictional issues, let me offer this approach to you. In my presentation, I will try to base myself on a practice that I had since 1972 up until today, and that covers 42 years, and that was virtually the only thing I've been doing. And over that long period of time, I did it as a researcher, as a teacher, as an expert, as an arbiter, and as a lawyer. So from these perspectives, it is from these perspectives that I will try to tell you about it. The idea of out-of-court protection of investment did not emerge recently. It has been a reality, say, back in 1972, when the Second International Congress on Commercial Arbitration, held by the International Chamber of Commerce, issues about investment disputes were discussed, the importance of arbitration, commercial arbitration in the first place, and they also discussed such a form as technical arbitration, which means mediation, if you take modern language. Interesting, isn't it? 42 years later, we're considering mediation as if it was something new, even though presentations were made by lawyers from many different countries. They proved it then, in 1972, that arbitration is a preferred form of dispute settlement compared with the jurisdictional one. Interestingly enough, for most states, that was a topic for discussion because it was an alternative, state or non-state form. And it was not very interesting for the Soviet Union at the time because there was no judicial form. All projects, well, the judicial form existed, but the competence of general jurisdiction courts did not cover. There was such a form in 1972. Yes, there was, but disputes were not considered related to investment in courts. And no one can tell me, not a single case dating back to 1972, 73, 74. All cases were considered in arbitration tribunals only, either in the Soviet Union or in Stockholm, with just a few exceptions in favor of Vienna or London, but those were rather exceptions from the general rule. A feature of that time was also the fact that arbitration was highly effective. The reason for that is that arbitration awards were indeed final. They were never reconsidered and were always observed. And you know why? There's two reasons to it. If the award was against an entity, a, say, Soviet entity, it was abided by, it was performed with no reservation, because there was the will of the party and its agencies for the that awards must be complied with. And a foreign investor investing in East Europe or Soviet Union couldn't even imagine it a nightmare that he could do anything but comply with the arbitration award for one reason. The borders of his business would stop at the Berlin Wall. Just as any tourist visits and meeting his girlfriend in the Soviet Union or Eastern Europe. And this approach was shared by Eastern Bloc countries. So this advantage was doubtless, and besides, there was this, the doctrine included was based on a conviction that the arbitration clause has a priority over the right to go to court. But that was in theory and existed for a long time in this theoretical form. It was substantiated by two persons here, your personal server and our moderator, who was our teacher. And in 1992, when investor disputes became competence of court's general jurisdiction, eventually a decree of the Supreme Court of the USSR at the time was adopted. Okay, that was not me, it was Kudryavtsev, someone, of course, I've known for 30 years, so it's not such a bad mistake after all. Yeah, of course, you're right. And now that decision was on that joint venture in Yakutia. So back in 1992 or 93, if memory serves, there was this decree of the Supreme Court of the USSR accepting the priority of arbitration clauses. So everything worked out fine, and this is the history of alternative forms for dispute settlements. Now, speaking about the material side of this issue, how do you handle disputes arising out of investment projects? Now, first, you have to look at investment projects. What are investment projects? How do you define them? Back in 1986, right on New Year's Eve, two decrees of the Council of Ministers of the Soviet Union at the time were enacted, number 48 and 49, on the establishment of joint ventures in the USSR. It was in the United States at the time. It was kind of an explosion of hopes, of prospects. And these two decrees, number 48 was about the Eastern Bloc, and 49 was for Western countries, aimed first and foremost at the establishment of joint ventures in the productive sector. It was not the purpose to raise capital. The purpose was to raise investment, to bring in investment and managerial experience. Now, after that, year 1987 came, and some dramatic changes took place in this country. Those changes were about, well, a new legislation, the emergence of the Russian Federation, and everything around that. Now, interestingly enough, if you analyze legislation in real life, you will see that real life went into a completely different direction compared with the ideals of 1987. You can discuss anything. However, what is not true is that managerial experience and capital is a priority of modern times. And I am absolutely certain about that because, one, I follow various sources, both legal and otherwise, and number two, this is based on the fact that last week, I believe, was it, or the week before, the Institute of State and Law, the chairman, Professor Novoselova, made a presentation stating in particular that disputes in court around compliance with license agreements or joint developments are an absolute minority, while trademark disputes, or who owns what, actually, which is characteristic for privatization periods, are prevailing. So we can see that the legal space is now facing a situation where law is not an incentive for the promotion of investment activities, and consequently any legal application or alternative dispute settlements. Now, I have only mentioned the federal laws that are currently covering investment activities, and it's good that Vladimir is here with us. Now, oh, thanks for remembering me one more time. He's not just a moderator. So the idea might be good. The idea about these laws, they may be based on lex generalis and lex specialis, general and special legal provisions. But having looked at them one more time with more attention, I would call them a reflection of the author, because the author is present everywhere. It's about concepts, internal, domestic or international relations. They are so confusing here, or maneuvered in such a way that investment can be gained here only, you know, by whom? Only an external lawyer, external counsel, because starting any activity without a serious study of these 2 or 4 laws will be a crime. You got to study them very attentively, or that will, or you will continue to be in the dark. So this is where we need to set things in order, because some provisions in these laws are mutually contradicting. There's no logic. Then there's another law on the protection of investment, and then on the constituent entities of the federation. So you can either get lost, or you gotta pay, I mean, to your counsel. Well, for information, since you mentioned that, and there's 5,000 federal laws and federal constitutional laws, and 158,000 laws of the constituent entities. This is quite some room for lawyers to work in. Yes, now some more key issues. To enter a market with an investment, everyone dreams of having his or her investment protected. Now, going to international forums, since the time of the legislation on foreign investment, that dates back to 1987. Quite some time has lapsed since then. There's one mandatory issue about nationalization. I keep asking the same question. Can anyone tell me one case of nationalization in the last 30 years? There's silence in response, but this item is always on the agenda. Another point is these 2 decrees were adopted more than 30 years ago, and they are about investment in Russia in general, any investment. But no conference can study all the issues around investment. If we're speaking about investment in general, you can't cover all those topics in a couple of days. So since I'm running out of time, let me just touch upon a couple of areas that you can't miss when you discuss investments in Russia. One, use of natural resources, including the energy sector, and 2, which is extremely relevant today, is about innovative development. These are the 2 areas that are the backbone of the Russian state. Nature is given by God, but God has also given us reason, so that we can develop our natural resources. But it should all work together. And in this respect, let me note that issues related to exclusively arbitration forms of dispute settlement and protection of rights have their limits, and those limits are much narrower than in areas such as tourism, services, etc. Why is that? The reason for that is that they are they are related, they're around entities or assets that are the exclusive competence of state courts, state jurisdiction courts. That is where public interest is involved. The practice of arbitration tribunals, and if you look at the judicial practice of both Russia and international practices, there's a trend that indicates that disputes arising out of such projects can be arbitrable if obligations that fall under the competence of arbitration tribunals are independent with respect to issues of ownership titles or validity of rights. Now, if we had a course for university students, this would be a great idea. But I am not speaking as a professor or researcher right now. I'm speaking as a lawyer, and I am strongly convinced that starting from the point when investment agreement is made, say about the introduction of new technologies and a potential dispute, certain relations will emerge, not only of legal nature but technical, related to the improvement, implementation, to what a form of remediation or defense for your technical solutions can be used by each party. So in practice, the issue of relations between the recognition of rights and their exercise are closely related. So the arbitrability becomes narrower.
As to property related issues and natural resources, and fuel resources in the energy sector, that's different. But again, everything depends upon the consulting lawyer. And in a specific dispute, these areas can be easily connected. The arbitration clause and risk of its reality increases. Now, about sadder things. The sun is shining now, so it's safe to talk about that. The law of arbitration has mutated. When I was a younger person, I heard that arbitration is the cheaper option. Now I can say, as the theater director Stanislavski said, I don't believe that. It's just not so. The second thing I heard as a younger person was that arbitration involves experts, which is true. But I used to hear that the experts have to be narrow specialists in a specific field. Now, this is not so. Say there is a dispute that will be arbitrated in Stockholm. Certainly, each party will choose its a lawyer to represent it. And these people tend to be either a law professor that you were the student of, or a colleague with superior experience. And I'm not saying these people are not going to be neutral and unbiased, but it does not mean that this person is going to be a narrow specialist in a particular area, something, say, construction. Hardly that. Then each of these councils are going to be a person from the country that is party to the dispute. The president of this tribunal is going to be typically a Swedish lawyer who may not be a great specialist in the finer points of Russian law. So what I'm going to invite you to consider is the convenience and relevance of national jurisdiction tribunals who tend to hear hundreds of cases within one specific sphere of law in a typical year. Another thing that I need to mention is the enforcement and the preservation of the spirit of arbitration. Today, the Russian Federation leads the world in the number of claims against the awards of arbitration. This is something that is a statement reflecting upon the business sphere of Russia. Arbitration proceedings have become more heated than typical litigation. And one last point that I want to address to Vladimir Nikolaevich. This point is connected with the informal character of arbitration and confidentiality of its procedures. In my view, the draft law on arbitration that we have today is going to bury this idea. Thank you. All right, the sun may be shining or not, but the academician Lisitsyn Svetlanov promised us to draw a cheery picture. I'll have to add to it. Certainly working with the arbitration clause may not be very easy and straightforward, and difficulties arise when courts of arbitration accept a case and then it is contested. Still, the Russian Federation has a developed system of mediation, and the Russian Commercial Court has contributed to this possibility, and we have arbitration tribunals, and we have to consider the International Arbitration Court working under the aegis of the Russian Chamber of Industry and Commerce, which is doing its good work. And although we know there are some legislative difficulties that need to be straightened out, still we want to invite everybody here and also colleagues from the Russian Academy of Sciences to participate in the discussion of the draft law. And Mr. Ivanov will have seen it too, right? So everybody is invited to take part in that discussion, which will be a way to improve it. And now I want to give the floor to Marta Petergas, First Secretary of the Hague Conference on International Private Law.
Well, thank you very much, and my apologies that I will be the only speaker who is not able to address you in Russian.
You have a great chance to study this language.
Yes, I will consider it, given that I was about to say that it is also a great pleasure to be here in St. Petersburg. It is my second time, and it is really a very fascinating city. And also, it is my great pleasure to represent here the Hague Conference on Private International Law, which you may know has been a firm believer of the International Legal Forum since its inception. This is our, I believe, the fourth gathering, and it's also our fourth participation. And so you see that we have always been an active participant in this forum. I thank you for giving me the opportunity to speak as last speaker, and also the co-panelists, because they have already given me some further ideas about how I could complement their observations. Of course, I will zoom out in the sense that some considerations have been given to the situation of the Russian legislation and the situation of ADR in the Russian Federation. And I think my role here now would be to tell you in very briefly how the work of the Hague Conference is relevant to the topic we are addressing here today, how possibly it benefits or it protects companies involved in foreign, in cross-border investment. Maybe some words of introduction about the Hague Conference. I don't know if you are aware, it's an intergovernmental organization which unites almost 80 states, including, of course, the Russian Federation, which has been a member, an active member of the organization almost since the beginning. And you also have to clearly understand that this is an organization that creates laws. And maybe you don't need new laws, new conventions, new instruments, because I have understood that there is already quite a few that are in place and are being developed. But let's say that the Hague Conference would help any of the members of its organization to have some international standards that could possibly be a source of inspiration for legislative projects. And so the question that I would like...
Thank you very much for these suggestions. Yeah.
Yes, so I thought then that I could possibly, in line with what the other speakers have presented, give you simply 3 examples of how some instruments that the organization has created could be relevant to the question we are addressing here about the legal framework in which investors operate whenever they cross borders. And just 3 examples, and I'm happy to come back to any of those or any other later on during the discussion. The first one is a very simple convention which was set up in 1961 and that has been joined since then by no less than 160 states. So, sorry, not 160, but 106 states. So even in English, I think I have to improve my English first before I turn to Russian. But how is this instrument relevant to the topic we are addressing here? So I understand Mr. Ivanov has referred to the administrative burdens. He's looked at it from a more national perspective. But I think it's also important in an international context, because sometimes things as simple as having documents that have legal effects in another jurisdiction may be considered a big administrative burden and an element that a company is going to take into consideration. So what does this apostille convention allow to do? Well, get rid with the requirement of legalization of foreign documents. And of course, that means less costs, that means less time, and so it is getting away with one additional administrative burden. And this is something that, of course, I'm happy to say as a representative of the organization, but what is also very interesting is that the World Bank itself has seen that link. Because you may know, and this brings us back to the idea of the rankings, whether we have to believe in rankings or not, But there is yet another ranking established by the World Bank that classifies jurisdictions in terms of their investment friendliness. How open are they to foreign investments? And it is very important that the World Bank has said that joining this convention, and by the way, for the Russian Federation, this is passé because the Russian Federation is a contracting state to this convention. It provides a full additional point in increasing your ranking in that World Bank classification. So it's not so directly relevant to Russia as a recipient of foreign investment, but I thought it was maybe very important for Russian companies when they decide where to invest. And because the outline said that we would look at the topic in the two directions, I thought that it was important to say that the convention keeps attracting new contracting states, that in particular we see now a recent trend from many African states to join this apostille convention. And so it shows that there is something as simple as suppressing the legalization that, in a way, gets rid of this administrative burden. This is a first example I wanted to bring to your consideration. A second one that I think has also been addressed by the previous speakers is the predictability as a necessary feature for investment transactions. A foreign investor will not happily enter into a transaction in a jurisdiction he's not familiar with if he at least does not get any some kind of idea about what is happening if something goes wrong. Because if everything goes well, then probably there's no problem, everybody will be happy. But what happens if something goes wrong? And I think that Mr. Ivanov referred then to an unforeseeable example like the protective employment rules that may operate in a legal system. And this made me think about another panel discussion I heard earlier on this morning, and which is about what rules are to be considered mandatory. We all have an idea in our own legal framework about what rules are mandatory. But how many of those also would qualify as overriding mandatory rules in the sense that they should apply no matter what where the parties are located, also to international transactions? And I understood in the previous panel that here in Russia there is this ongoing debate about how many of those mandatory provisions in a national setting would also be considered overriding. Is this something that has been addressed by the Hague Conference? Yes, it has, and even here I would like to give you a very recent example of our work. We have developed, and we are about to adopt, an instrument called the Hague Principles on International Commercial Contracts. What is this all about? It is simply about making sure that whatever parties set up in their contract as being the binding law among themselves is respected as much as possible in no matter which jurisdiction where this contract will operate. This, of course, you see, it's all about party autonomy. It's about the possibility for parties to choose the governing law and the governing provisions, but it also clashes with some parameters that each legal system of ours has and has to be respected because it represents essential values of each of our legal systems. So the principles then, I think, have contributed to that ongoing discussion, and by means of some rules, and also by means of an authoritative commentary that has been developed by a group of leading experts. And in this context, I would also mention, I don't know if you know him, Mr. Ivan Zikin. He has also been a member of the working group and has helped the working group develop these rules. So I think this will be, again, an international parameter that states like the Russian Federation could consider if they would like to clarify further which mandatory provisions should also operate in the context of cross-border investment transactions. This is my second example. Let me just, as a last one, refer to our work in the area of international litigation. And it's striking that I think we have here a panel of people who are all firm believers of court adjudication. But we have been asked to talk about non-court systems. And so I was then very interested to hear some of the elements that were presented by Mr. Lisitsin about the balance between arbitration and litigation. But here what I thought was relevant in terms of what the organization has done, we have created a number of conventions that you may know because the Russian Federation is a party to them, on service, on taking of evidence abroad, on choice of court agreements. So all these instruments, I think, also facilitate parties entering in international transactions. Somehow they reduce the uncertainty that the international character of the dispute entails. And so, although you would then possibly say, yes, but they only operate if we are before courts, don't they? Yes, that's right. But I think I would like to propose the observation that they are also somehow incentive for parties to not to blindly go into litigation, but rather to settle the disputes. And so there is, I think, a link between the work that the Hague Conference has developed in the area of international litigation and the encouragement that I think should be given to the international legal community to solve disputes outside the courts. As a last point, if you allow me 2 minutes of public relations, if you're interested in hearing more about the Hague Conference, the Secretary General of the Hague Conference will, in half an hour, present about the organization at the atrium downstairs. Thank you very much for your attention.
Thank you very much for your impact. Если позволите...
If you will allow me, I would like to give the floor to Yuri Kirillovich, to Academician Tolstoy, that is. Maybe if Academician Tolstoy still would like to do that, we would be happy to have you here among our speakers. I'd like to remind the colleagues present here, above all my colleagues from Russia, that at present we are witnessing a very heated struggle, not just for economic space, but also for the legal space. And it is imperative that we are cautious about recommendations that are given by corporate sector lawyers. Please don't misunderstand me. I don't mean there is ill will in what they do, but a lawyer who was nurtured by a specific legal system, say the Anglo-Saxon system or the continental European system, it is only to be expected that such a lawyer will work towards broadening the jurisdiction of that particular system. For us, and from the point of view of private and public international law, this may not always be the best thing to happen. This is just an observer's note. Thank you very much, Academician, for this remark also. Colleagues, if you have any questions for the speakers, now is the time to ask them.
Thank you for your comments. I work in a English law firm. I'm a Russian lawyer, a partner in an English law firm. I think that your concern has no grounds. And so I have this question to you. Crimea is a great place for foreign investment, a remarkable place. Sooner or later, statesmen will have to recognize it as a Russian territory. We're totally convinced, even though legally there are issues about it. But some foreign investors will be the first ones to recognize that and will enter through affiliated companies. So the question is this, and this is a fairly painful topic. The nationalization of Ukrainian property. Because in our view, and we work with real estate, we believe that you should be happy with the fact that Crimea has become Russian territory. But nationalization will be a mistake, because nationalization leads to a situation where nationalized assets will become problem assets for years. They will be subject of court settlements, there will be no investments. Maybe a better way would be to leave them to those who own them and then introduce a regulation for these assets under Russian law. See what happens there and force them to work within the law or force them to sell their property. That's my first question, and I'm sorry for taking this opportunity to ask a question to Anton. What do you think? Neutral foreign investors, are they positive or negative about the merger of two courts? Because in our practice, your authority grows geometrically. Let me answer the second question right away. I think foreign investors know nothing about this merger or unification of the different courts. I don't quite remember. There's an economic board and some members of the High Arbitration Court of the Russian Federation will be part of that board. So the next point is that the practice accumulated by the Supreme Arbitration Court of the Russian Federation contains a special rule that says that the practice accumulated by the Supreme Arbitration Court remains there, and this is quite natural. This practice remains, and any rulings or awards of the arbitration court remain valid for the entire period and will be become void only if the unified court makes a decision otherwise. So this is what brought about the reaction. And this is reflected in the legislation. Now, as regards your first question, or not even a question, but a desire you expressed, the Russian legislation, constitutional law, establishes a period for the formation of a new judicial system. Tomorrow, decisions will be taken to give the same rights for companies registered in the Russian Federation in terms of their relations with funds like the pension funds, social funds. Therefore, this becomes effective August 1st, 2014, if I'm not mistaken. partially 1st January 2017. Well, this law will be considered tomorrow. And there's no doubt that foreign companies do pay attention to on the territory of these new constituent entities. And to your questions of property, your remark is valid, and the formula for the solution of various properties must be developed. Yes, please. Regarding your first question, let me express a few considerations. The question about nationalization is not a new one. And I agree with you. It's true that when you have nationalization, this brings about risks for investors, for businesses. There's no doubt about it. Now, the fact that you should not rush here is something I agree with you too. But let me make a few other points that the Russian officials should pay attention to, and as well as the investors. The issue about the recognition of nationalization acts in this country have judicial precedents in France, England, and United States. These are fairly old cases dating back to 1920s and 30s. They're described in old literature. It's fairly easy to find them, and that's a way for a solution. But there's another interesting point here that you need to study when doing various projects. Between the time when new constituent entities are exceed the Russian Federation, there's an announcement of or declaration of independence of those entities. So what happens in between? Of course, there's a few forgotten institutes in law, in international public law, which is about the law of about the situation of a territory which is not recognized by other countries. Now, Shibanova's book about the right of the Russian Federation to properties, real properties located outside of Russia. This was mostly true to entities, assets that belonged to the Soviet Union and now belong to the Russian Federation. In particular, the house at Rue Voisier in Paris, which always belonged to the Russian Crown and then the Soviet Union. So there's some interesting material here that you can look at, but no doubt it's the 21st today. No, it's the 19th. So my advice to Russia would be, starting June 19th, 2014, don't rush nationalizing anything. Let's admit honestly that it was not our objective today to discuss this issue. We cooperate with Kommersant newspaper. We stay in contact 3 times a day, so we won't go into much detail to discuss non-jurisdictional defense of foreign investors. There's a negotiation process, and mechanisms are being developed to guarantee mutual interests of all the parties to the process. So unless my colleagues add anything, let's stop here and let's put a full stop and consider your question answered. Tomorrow I will move my money from my Visa card to my MasterCard. Good afternoon. Oleg Norin, lawyer from Simferopol, the Republic of Crimea. As noted already today, nationalization is on the agenda, but that's not only valid for properties, but also corporate titles like corporate shares of Ukrainian companies. And as noted earlier at a previous session, a favorable investment climate is based on some good legal foundation. So in our republic, we've left outside our attention the rights of stockholding companies and the right of private Ukrainian companies to so I don't think this is up to the republic itself to address this issue. So it's outstanding, it's unresolved on the part of the federal authorities for the time being. And at present, the constituent entities of the Russian Federation, the city of Sevastopol, and the Republic of Crimea, they have the legislative initiative. They're represented in the Council of Federation, and there are working groups set up with representatives from your legislature working actively there. So if you deem it necessary to draw the attention of the federal legislature to a point, then according to Article 104 of the Constitution, you can do so and ask any of your colleagues who have the right of legislative initiative, and that includes some 29 constituent entities, who have the right of legislative initiative. Well, our colleague mentioned 720 authors. So if something is unregulated and you believe it must be regulated by federal law, then this would be the way for you to take. I don't remember the details of stockholding legislation. If you believe something must be done there, then Professor Korsheninik, who's in charge of these aspects and at the legislative committee, can of course interact with you in this respect. Yes, please. Good afternoon. Oleg Tarasov, Deputy Manager Special Projects, Gazprom. I would like to ask this question. Recently, the protection of investor rights is shifting from public law, investor-public relations, to private law relations. Because private investors in Russia, they protect their rights by including it in the agreement with the Russian partner of terms and conditions to guarantee the return of their investment in the event of negative changes. Then the Russian party assumes the obligation to buy out the stake of the foreign partner if the project turns out to be less profitable than expected. This brings about a different, gives rise to a different problem. If the investor go to foreign courts for enforcement. And any claims brought with foreign courts, they include issues that are the exclusive competence of Russian courts. So what happens in this situation? The claim is brought on the territory in the court of Germany. Then the German court sends the request for legal assistance to Russia. Then the Russian court transmits the claim to the Russian respondent, making it possible to continue the settlement procedure in the German court. Now, the Russian company, when getting enforcement, presents an application for the instruction to be performed because it's contrary to public order, which means that it will make it possible for a foreign court to consider a dispute which is in the exclusive competence of the Russian courts. However, Russian courts often take this enforcement in the following way. Their position is that the court works like a postman who transmits the claim without discussing the substance, even though the procedural legislation makes it possible based on motives of the claim being contradicting the public order. Now, the procedures may not be contained, making it possible to claim against. And in this respect, I wanted to confirm, is this issue of, in the specter of discussion of our legislature, and are there any plans to adopt any laws to regulate this issue one way or another? Thank you.
Well, let me respond by this comment. I think it's a specific request about a specific case. I can give you a more general answer. If we are to have the rulings of our courts executed in other jurisdictions, we must make sure we execute the rulings of other courts in our country. That's a must. And this is happening, and this has impressed international courts as well. Say the Cassations Court of France has executed several of the rulings of Russian courts, so have German courts. And this is the right way to go. This is a good positive example. This is what we need to see more of. Without that, Russia will never get out of this jurisdictional isolation that has until recently characterized our country. That was my general comment. As to the specific question that was asked here, I would say that the implementation of court orders have never come up before Supreme Courts. At least no comment was made by the Supreme Courts on that. And I can hardly say what the ruling would be. Looking at it from the constitutional viewpoint, if a legal act makes it impossible to proceed with a case, then this act can be appealed against, even if it is not stated anywhere in so many words. So this situation will need to be discussed further, but these are the prerequisites. Thank you for your question. I would treat it more conservatively, and I could offer a more conservative view of that. This freedom of choosing a jurisdiction to use is a new thing. It is based on what I see the Mitsubishi case from the United States, the long arm rule. When the presence of the respondent in a particular jurisdiction is viewed in very broad terms. This is also something that we find in continental law these days. I agree with Mr. Ivanov when he says that there are some positive examples of execution of court rulings without an international agreement existing. But this only happens when a foreign court considers a case. It was only matters of material importance, not of procedural importance. Something that did not involve the use of Russian jurisdiction and so on. Those were black and white cases, if you know what I mean. But what if it were indeed matters of procedure, say, the applicability of Russian jurisdiction to a particular case? So, looking at it in a more conservative way, I would go for the international agreement first, which could designate jurisdictions. And that would then take care of all the minor issues such as the subpoenas and the right to appear before the court and the execution of the rulings and so on. Currently, the situation is not very favorable for that. In Europe, for instance, in the European judicial system, the order of the day is something different. It's mostly regulation within the European Union that concerns everybody there. However, this leaves big markets such as the United States, China, or India, where international treaties are not regarded as the best form of settlement. And this will need further work, and maybe we can address ourselves to the Hague Conference. The Hague Conference seems to be the only place in the modern world where such objective difficulties can be addressed.
Thank you. Just a couple of remarks, because indeed 2 days ago we we organized a side event on something that is directly relevant to what you just asked. There is indeed already a 2005 Choice of Court Convention that was concluded under the auspices of our organization, and that is currently being studied by the Russian Federation. Granted, this convention has not yet entered into force, but when it does, and I invite you all to read all about it in the Forum newspaper, yesterday's edition, front page. You can read about it. This convention, I think, will give an answer to your question. It is a convention that, in a nutshell, makes sure that whenever parties in an international contract have determined which court has international jurisdiction, that agreement is respected. It brings me back to what was discussed before. How does this relate, party autonomy, with the fact that the Russian Federation has legitimate considerations in terms of which matters have to be governed by exclusive jurisdiction grounds? This is a policy matter, and this is the question that the Russian Federation will have to examine when it hopefully accedes to the convention. But the way has been paved by the fact that important trade partners of the Russian Federation are further away in their process of ratifying the convention. Reference was made to the European Union, which we hope later this year will ratify the convention, and the convention will then enter into force, and we hope that then it's only a matter of time before there is a reliable international instrument. There's also ongoing work, the so-called judgements project, because it is, I think your example related specifically to a situation where there is a contractual agreement among the parties as to where to litigate, but you can have tort cases, you can have other contractual matters where there is no such agreement. And so are we going to go as far as to create an international framework to recognize and enforce judgments? Mr. Ivanov says, oh, it works as it works today. It's the system of reciprocity. Well, I can say from my perspective that in some European jurisdictions we have left reciprocity behind as a system that is very difficult for courts to apply. And we have considered other possible conditions that would have to be met before a foreign judgment can sort out effects in the forum. Again, it is a policy consideration, reciprocity, other mechanisms, but at the Hague Conference we are trying to indeed come up with some common international standards also in this area.
Возвращаясь к части вопроса, конечно же, каждое государство.
True, it is a matter of policy for each state about exclusionary jurisdiction. It's the Brussels Convention and the Lugano Convention that come to mind. And under certain conditions, states will have to protect their residents if their rights are violated. Going back to your specific question, Mr. Ivanov responded by saying that you seemingly cannot appeal, but of course you can. You can try to do that at least. Are any more questions? I don't think we have time for more questions. With a few lectures coming up, and one of them a lecture about the Hague conference, we must stop here. Thank you very much for being here and participating in this roundtable, which was a bit more advanced and complex than the one we had here last year. Today we had no time to talk about Russian mediation law and its prospects. I believe there must be a roundtable discussion on that, maybe next time, next year. So make sure you are here for this next year. Enjoy the lectures that are going to be offered. Enjoy the city of St. Petersburg. Make sure you also spend some time outside walking during the night when the bridges will be raised. Thank you once again for being here, and all the best.